Hello. If you're watching this video, you've either registered for IBB Law's Virtual Mock Employment Tribunal hearing or are considering it. My name is Mark Jones and I'm a partner in the Employment and Immigration Department at IBB Law. I've been involved with employment tribunal claims for over 25 years, acting for both employers and employees. I've appeared in employment tribunals around the country, the Employment Appeal Tribunal in London, and the Court of Appeal. Based on my experience, I have devised and written this production. The production will be as authentic as possible, and as this will be a virtual hearing, we will be at the mercy of broadband connections. The hearing will be chaired by a real employment judge, and the advocates are real barristers. The production has not been scripted, and the decision has not been predetermined. The production will take about 2.5 hours in total, with a break for a short poll before the employment judge delivers his decision. Any questions that you have about the production will be answered by me in real time during the hearing. The tribunal consists of an employment judge who will be a qualified solicitor or barrister of at least 7 years post-qualification experience, 2 wing members, one normally with an HR employer background and one with an industrial relations employee worker background. However, unfair dismissal claims are normally heard by an employment judge sitting alone. Hearings follow a similar format, albeit an employment judge has discretion to run this as he or she thinks fit. The side that normally presents its evidence first will be the one that has the burden of proving it. In an unfair dismissal claim, the respondent will go first, as they must show that they have a potentially fair reason for dismissal. Whereas, say for a discrimination claim, the claimant will go first, as they must prove that the respondent's conduct amounted to unlawful discrimination. Where you have a mixture of claims and one is unfair dismissal, the employment judge will decide who goes first. Employment tribunals were originally designed for litigants in person, but due to the often complexity of the claims, we advise that parties have professional legal representations, and preferably from IBB Law. Presenting evidence will normally consist of witness statements being taken as read, then possibly being asked a few supplemental questions by their legal representative, referred to as evidence in chief, and then ask questions by the opposing legal representative, referred to as cross-examination. Once evidence has been concluded, each representative will provide closing submissions summing up each party's case. Normally, the party who gives evidence first will give their closing submission second. At the start of a hearing, employment judges often seek to clarify the issues relating to the claims to be determined and what each party must do to establish their respective case. This now leaves me to introduce the cast. The employment judge is Andrew Allen QC from Outer Temple Chambers, a leading barrister with a successful employment and discrimination practice encompassing 2P, contractual disputes, and discrimination. The barristers are also from Outer Temple Chambers and are, for the claimant, Joshua Kaner, and for the respondent, Imogen Egan, who both specialise in employment and discrimination law. The claimant will be played by Sarah Jane Bevan, a senior legal administrator in the Commercial Property Group at IBB Law, and the respondent's witness will be played by Paul Rideout, partner at IBB Law, and head of our charities department and a leading practitioner in charity law. Thank you very much for listening, and I hope you enjoy the production.